case, my lord, I have awarded cost of 20,000 on 16/9.
उसमें क्या करना? कॉस्ट तो देना पड़ेगा ना?
Lord, the fact is, Lord, I and my friend is also present in this court.
I can't.
Through
Did you appear when the case was called out?
on 8th, my lord,
आपको वीडियो दिखा दिया गया है ना, आप नहीं थे ना?
उस समय तो
बस उसका हम कुछ नहीं कर सकते, अलर्ट रहना आपका काम है। इसीलिए हमारा ये सब रिकॉर्डेड है कि कोई कुछ बोल ना सके। इसीलिए हमारे स्टेनोग्राफर ने मुझे आके बताया था, ऐसी बात नहीं। पहला तो हमारे स्टेनोग्राफर से किसी को मिलने का कोई काम नहीं, प्लीज डोंट एवर डू इट। उनसे मिलने का कोई काम नहीं है। Either you can come to me directly or you can come through the court. पहले तो हम उसको यही डांटे कि why did you indicate anything?
ये उसमें हुआ क्या किसी
कुछ भी हो जाए, आपको हमारे स्टेनोग्राफर से मिलके कुछ भी बोलने का कोई काम नहीं। वो लोग कंफ्यूज हो जाते हैं और परेशान हो जाते हैं, ठीक है? पिछले दिनों कुछ ऑर्डर्स ऐसे हुए जिसमें जो आदमी अपीयर नहीं हुआ उसका अपीयरेंस रिकॉर्ड हो गया, थोड़ा 1 साल 1.5 साल पुरानी बात, ठीक है? तो जो चीज़ हम बिल्कुल पसंद नहीं करते और हमको एकदम वीडियोग्राफी की तरह याद रहता है, जैसा वीडियो रहता है वैसे ही याद रहता है हमको, जब तक हम ऑर्डर साइन ना करें।
ठीक है, हम हमारा सेकंड पोजीशन में था फाइनल डिस्पोजल में। 8 तारीख को डायरेक्शन हुआ कि कॉपी जो है
हम इतना जानते हैं, केस बहुत लाउडली कॉल हुआ था और आप जब केस टेकअप हुआ तब आप हो सकता है कि अदरवाइज इतने अटेंटिव ना रहे होंगे, ठीक है? तो आप नहीं रहे थे तो उसका तो हम कुछ कर नहीं सकते। इस तरह से ऑर्डर रिकॉल नहीं होता, ठीक है? रिकॉल हम नहीं करते,
पिटीशन
हम करेंगे नहीं, अभी से रिजेक्ट कर देंगे। अलर्ट रहना भी वकील का काम है। और ये लोग बहुत जोर से बोलते हैं मेरी तरह, as loud as me, वहाँ तक सुनाई देता है, डिटेल को वहाँ बैठ के ठीक सुनाई देता है क्या बोलते हैं। लाउड स्पीकर की जरूरत नहीं।
जो सच्चाई है कि दोनों
हम भी तो सच्चाई की बात कर रहे हैं, ऐसे नहीं कर रहे। 4:30 बजे के बाद हम कॉस्ट का ऑर्डर नहीं करते हैं इन प्रिंसिपल। तो क्या होगा? आपको पता है कि फर्स्ट सेकेंड हाफ में तो हियरिंग मैटर्स नहीं टेकअप करते हैं, तो इसीलिए आप 4:30 बजे तक बैठे थे तो आपने लिस्ट ठीक से नहीं देखा। अरे भाई, आपको एडवोकेट वो क्लर्क एसोसिएशन को देना है जिनसे आप दिन रात काम लेते हैं, उसमें आपको क्या परेशानी है? हम थोड़ी सरकारी खाते में पैसे तो क्लर्क हम खुश रहने दीजिए, उनके वेलफेयर के लिए बहुत जरूरी है। देखिए उन लोगों का कुछ भी ढंग से नहीं हो पाता है। क्लाइंट नहीं देता है कॉस्ट, वकील साहब का नहीं आपके नोटिस से, हम तो नहीं देखे अपने प्रोफेशन में ऐसा। जब रेस्टोरेशन में कॉस्ट इंपोज होता है तो वकील साहब अपने पॉकेट से पैसा भरते हैं, करेक्ट? हम लोग आपका एक मेंशन केस था, ये सिस्टम मैनेज आर देयर।
Out of that case, item 46, second appeal on 53 of 2018.
The second case also before lordship.
Yes.
That is 17.
Yes, Mr. Banerjee, have you appeared in this case?
So far as the other second appeal.
I don't know, which
No,
is listed today.
It is yes, I appealed in this case.
All the respondents have appeared.
Yes, there is sole respondent.
Sole respondent. What is the matter about?
The matter is they filed a miss case for intervention under the provisions of Order 21, Rule 97, rather it was Rule 99. In the execution
I think I have passed an
Yes,
elaborate
there was an order, an interim order stay since another second appeal was pending. Subsequently, what happened? In a shoot, our sale deed was declared to be null and void, and against that we are in second appeal.
So we'll tell if it is in the same order.
It can be
Interim order तब तक extend कर दें. It is arising out of the same proceedings.
No, different proceedings. It is in miscellaneous jurisdiction under Order 21, and that is a regular suit, arising out of regular suit.
Between the same parties.
Same parties. Only the tenant will be different, but
either between the same parties or claiming through the same parties.
yes.
SA number 153 of 2018, the learned counsel for the parties are present.
In the other second appeal, I am not representing the present respondent.
Who is there?
Some other counsel is there.
Mr. Nikhil Ranjan.
Mr.
Nikhil Ranjan. I've seen his name.
He must be the appellant.
Yes.
You must be the respondent.
Yes, I've
You should
appeared there.
inform him.
I'll inform you today itself.
Second appeal number.
154/2024 Melody.
The learned counsels have submitted that between the same parties and or persons claiming through the same parties are contesting the second appeal number
154 of 2024.
15 of 2024. That has been admitted.
No. Only on the point of limitation notice has been issued.
The said case has not yet been admitted and notice has been issued on the point of limitation. The learned counsel for the appellant submits that he is appearing for the respondent in the said appeal and he has already entered appearance. It has been also submitted that this matter be heard along with essay number 154 of 2020. Since the second appeal number 154 of 2024 has not yet been admitted, it will not be proper to tag this matter immediately, but both the cases be listed on the same date. 154 का कोई date नहीं है out of list. As reported by the learned court master, no specific date has been fixed so far as essay number 154 of 2024 is concerned. Considering the aforesaid circumstances, let both these cases be listed on. इसमें notice का कौन सा date है? बताइए कौन ठीक करेगा?
Immediately, my lord.
Yes, Mr.
So far as my appeal is concerned, I am ready. In that case, I cannot submit about that. But this case is ready. Whenever it is convenient in the Honorable Court, I will assist. So for this case is concerned, which is on board.
8 अक्टूबर को रख रहे हैं, पहले उसका लिमिटेशन चेक कर लेते हैं। कितना दिन का डिले है? How many days? डिले?
I am not having the file that file.
नोट आना चाहिए। देखिए उसको कितना दिन का डिले है। We normally
37 days.
हाँ?
37 days.
आगे You are the sole respondent in that case.
One of the respondents.
Fine. 8 अक्टूबर को रखना है। अच्छा इंजरी नोटिस वैसे तो कुछ हो ही नहीं रहा होगा
नहीं, नहीं,
डॉक्टर
they have- कर दिया जाएगा।
the interim order dated
9/7/2024.
9/7/2025 be continued till 8th October. उसको लिस्टिंग के लिए कर दीजिए 8 तारीख उसे मेंशन करके कर लेंगे कि कितना ऑर्डर स्टेज टेक अप
I'll mention it.
प्रोवाइडेड आई एम देयर इन द
Yes, ma'am.
वी डू नॉट
And I'll inform Mr. Nikhil.
हां उनको
From supplementary list, under heading for orders, item 2, first appeal 367 of 2018.
What is the IA number?
IA number 13505.
13505
505.
सबका कवर हो गया
Subka name of petition. Few of them we have excluded.
excluded
Yes, because they have died and further their legal heirs have also died and the date of death of their legal heirs has not been written.
so
There is and
so
also
under such circumstances the award will become final against them
we will file this once they will provide the date of death of
आप इतना नहीं कथा कहानी करिए ठीक है ना आप अपना डेट ऑफ नॉलेज से चलिए ना What is this?
ठीक है litigation next date तक
किस तरह का ये आप लोग का अप्रोच है
As per my knowledge, as we have submitted all these substituted persons, last second last is similar as well. We have given in several cases this substitution because they are already correct. But if we still is saying, so I have to check, verify. Second thing there,
one more thing litigation. In FA number 292 of 2014, there has been written in IA that appellant number 11 may be deleted. And in that first appeal, litigation only 5 appellant numbers are. Only 5 appellants.
there may be some minor mistakes. I admit that.
Then it may be rectified by the litigation. That
in first appeal number 292 of 2014 he is the applicant
litigation, there are only 5 appellants in that case. But in IA, it has been written that appellant number 11 may be deleted.
forget it how does that make a difference it is absolutely inconsequential an appellant who is not there they
Ma'am, it's
matters
just
when you
appellant,
see they also get confused when there is no appellant number 11 the matter ends maybe that appellant number 11 might have filed a separate appeal we do not know since he is not there it doesn't make any difference
Only
आप
few
लेकिन
of them
अपना-
are only few of them are left litigation.
how many of them respondent number
13 list of 13 has been
Litigation only 10 to 30.
आइए 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 इसमें नहीं लगा
yesterday itself it was filed.
any objection to this
No,
item
no, no.
आप जो अपना फाइल करते हैं ना एग्जैक्टली इनके नाम से टैली करके लिखना है
हाँ वो वैसे
वैसे ही करते हैं मतलब
एग्जैक्टली इनका जो आईए है उसी से हम लोग देख सकते हैं.
अब तो आपने टाइपिस्ट का भी काम हमको करना पड़ेगा कुछ सोच के बता रहे हैं और कुछ देख के बता रहे हैं ध्यान नहीं देते आप लोग चीज़ से आप लोग तो टाइमिंग से करते नहीं हैं
For
टाइपिस्ट
that
को
purpose,
छोड़
soft
देते
copy has been provided so that they can copy it.
हैं अलाउ कर दें
One more thing was there कि there was a proposal for amicable settlement.
वो तो दे आर नॉट इंटरेस्टेड टू
आप 10 दिन है शायद अगर पूछते तो because
किससे क्या पूछेंगे हम लोग एंड हाउ मच कैन वी चेज राइट देयर वाज अ प्रपोजल कितना साल पहले
2020 5 साल
5 साल पहले से चल
अभी
तो कोई ये लोग तो ऐसे ही करते रहेंगे इनको थोड़ी फर्क पड़ा पैसा इनके पास है राइट दे डोंट बॉदर अबाउट इट आप लोग लड़ते लड़ते थक जाइए
वही चाह रहे किसी तरह से
यही चल रहा है
फिर अगेन दे विल गो टू सुप्रीम कोर्ट अगेन दैट मैटर विल लीगल चलता रहेगा
again they will go to supreme court against what
against this order when finally I order to pass on judgment they pass on this again so amicable हो जाता तो once and for all the certificate.
ये तैयार
तैयार नहीं है, लेकिन इनके
नेक्स्ट
ऑफिसर्स
डेट पे आइए डल
ऑफिसर्स बोले कुछ कि हाँ हो सकता है, देयर आर पॉसिबिलिटी, इसलिए हम इनको बोले
ऑफिसर्स के बोलने से ये मैटर सेटल होगा।
वो लोग रेडी हो जाए तो अगर हो सकता है, क्योंकि दे आर गिवन देयर कंसर्न कि ठीक अगर कुछ ऐसा आता है तो वी विल कंसीडर उसको।
आता है मतलब किसका आता है?
ऑफिसर्स
आपका जो प्रपोजल था वो तो हम ऑर्डर में लिख दिया that you want to settle with the awarded amount, correct? But they are not interested. आपको नहीं चाहिए ना? चाहिए, सुन लिया ना? ये सब मैटर्स जो है ना कायदे से मीडिएशन में ही सेटल होने चाहिए। ये CG सेम ऑर्डर करते हैं, लास्ट ऑर्डर सेम टू सेम।
on 7 I will file all the colors after verifying the list.
We file all the wakalatnama, you have received
On
it.
7 and but they take 1-2 days in the for registering them in the office, because bulk they will accept immediately.
IA number 13505 of 2025 in FA number 367 of 2018. This petition has been filed for substitution of following deceased respondents. पूरा list है इसमें। आप इसका सॉफ्ट कॉपी प्रोवाइड करिए, इतना टाइपिंग एरर होता
हम
है।
पेन ड्राइव में
The learned counsel for the appellant has submitted that the present application for substitution has been filed after it has been brought to the knowledge of the appellant about the death of the accused respondents. Prior to that, they had no knowledge of the death of the persons who are sought to be substituted / deleted. कुछ deletion भी है, deletion भी है. He has also submitted that these respondents have also been substituted in their corresponding appeals, which has been tagged along with his appeal. The learned counsel has further submitted that the substitution be allowed. Mr. Mithun Kumar, advocate, submits that he has received wakalatnama on behalf of all the proposed legal years and successors. He undertakes to file the same within a period of 15 days from today.
Yes,
Within a period of 15 days from today. Considering he has submitted that he has no objection so far as the prayer for substitution is concerned. Considering the future submissions, IA number 13505 of 2025 is hereby allowed. At this, the learned counsel for the appellant has submitted that there are a few other co-respondents in first appeal number 367 of 2018 in connection with which substitution petition is yet to be filed. He submits that once the substitution of all the concerned deceased respondents is taken care of by passing appropriate order, a fresh cost title could be filed. Pose this case on, बताइए आप कब तक फाइल कर देंगे अपना fresh substitution? Tell me.
1 week after holiday.
Pose this case on 14th October in the supplementary process. ठीक है, तो remaining lot उस दिन substitution करेंगे और आपको सुनेंगे. सबसे पहले किनको सुने? इन्हीं को सुने. सबसे पहले आपको सुनेंगे. आपने अपने written submissions डाला है. Have you done it? Have you prepared it?
Leadership prepare कर
क्या बनाइएगा कि prepare करिएगा? और in case अगर मान लीजिए कुछ bench या constitution में कुछ change होता है, then under such circumstances, since the entire batch is a tied up matter, it will come on the file. ठीक?
It stays at 215 item 34, content civil 717 of 2024.
Yes?
That university, but I may be committed to give a supplementary show cause on this issue. Here's a letter from this university to the state seeking instructions for payment. May not please come to pay you.
क्या वो आप लोग थे ना?
हमने तो फाइल सब्मिटेड सो इन पारा
क्या
हमने क्लियर लिखा है कि जो इनको समीप कुमार सरकार और नियमानुसार भुगतान किया गया जो उपलब्ध की गई राशि से।
कहाँ दिए कॉपी? किसको दिए कॉपी? हमको नहीं मिला है। May not please come to pay.
आपको कुल सचिव को सब मिला प्रधान विश्वविद्यालय चौरस्ता को मिला है सर।
हम पिटिशनर अपने बारे में बात कर रहे हैं। ठीक है सर।
कोई कॉपी मिली ऐसे नहीं है।
इसका कॉपी हम
कहाँ लिखे है बताइए ना। चलो कोई बात नहीं, कॉपी नहीं मिली आपका फेवर में लिखे तो आपको क्या तकलीफ है? पहले भुगतान ले लीजिए।
नहीं जैसे बोल रहे हैं कि मिली होगी तो कॉपी रिसीव होगा।
मेरा कॉपी का एक्सेप्ट हुई ही नहीं होगा वहाँ फाइलिंग से एक्सेप्ट ही नहीं किया।
ये 7 अगस्त तक 7 अगस्त का है ये।
नहीं नया एफिडेविट है हमारा 23/9/25 का जो एफिडेविट है डेट
आया ही नहीं होगा।
पैरा 11 12 का
मैंने 11
चेक करवा दीजिए।
फाइलिंग
सेंटर को कॉपी दिया था सबको दिया था
कॉपी मिली
यूनियन को मिला
यूनियन को मिला
हाँ मिला हुआ है
नहीं, ये तो यूनियन ऑफ इंडिया का एफिडेविट फाइल है। वो भी नंबर 3 की तरफ से आपने कब फाइल किया? इनको जरा देखिए क्या खुद ही नहीं पता है इन्होंने क्या फाइल।
हम ऐसे नहीं कॉपी
पैरा 11 एक और भी है।
got it.
It has been stated again, direction has been given to the university for dispersal of the said amount to the petitioner by letter dated 174 dated 23/9/2020. Of course, there is no problem. Yes.
23 सितंबर का चिट्ठी। हाँ ठीक है 2 दिन का ही है।
आपके पास कम्युनिकेशन होने में टाइम लगेगा, इसको ऑर्डर में ले लेते हैं।
ले लीजिए और हमको एक अगर इसकी कॉपी दे दो
मिल जाएगी ना, यू आर एंटाइटल्ड टू अ कॉपी।
पैनिक सर
मिस्टर आपका किसी को रिसीव किया गया, आपके ऑफिस में रिसीव हुआ, इनका कोई रिसीव नहीं है।
एक हमको दिलवा दीजिए।
इनका
इनका नाम बता दीजिए।
अब हम क्या बताएं, तो ऐसा घसीटा हुआ नाम लिखा हुआ है कि अरुण लिखा हुआ है, एस अरुण, ठीक है, और उस साइन है और आपका आइडेंटिटी
हमारा कलीग बोल रहा है कि हमने साइन
क्लर्क और काउंसिल हैज साइंड देयर इट्स नॉट
हमको सिर्फ
और इनका
दिलवा दीजिए।
इनका बाद परमिशन वाज नॉट इसके बाद इन दोनों को लिया
परमिशन से हुआ होगा लेट्स के चलते इम्पेडमेंट के चलते परमिशन से
ठीक देखिए contempt case civil number 717 of 2024. The learned counsel for the state has submitted that a supplementary show cause has been filed, which is dated 23/9/2025, and along with the said show cause, a letter dated 23/9/2025 issued to the Vice Chancellor, full certified Vice Chancellor Kolhan University. To the registrar Kolhan University, Chaibasa, has been annexed, and a statement has been made in para number 12 of the show cause that a direction has been given to the university for dispersal of the amount to the petitioner. Paragraph 11 लगता है हमको बीमार हो जाएंगे ये पुराना रिकॉर्ड से।
उसमें होता है ऐसा।
हम सब अपने एलर्जी से परेशान हैं।
एलर्जी से डस्ट एलर्जी से आदमी बीमार हो
11 and 12 of the posted affidavit is quoted as under. He submits that there is no impediment in making payment to the petitioner as of now. The counsel for the university is also present. He has taken note of the aforesaid statements. ये quote ही कर देंगे ना इसमें. Aforesaid statements made in the supplementary show cause filed by opposite party number 1. अब बताइए. अब तो पेमेंट में कोई दिक्कत नहीं है.
नहीं
कोई भी head
अभी
of
भी
payment
कहेंगे
नहीं.
इसको कॉपी दे, हम अपने से लिखना चाहते हैं इसके आधार पर कर हम इनसे मांग लेंगे
आप तो दिमाग से नहीं बात कर
सर ये कॉपी एक पेज दे
हम ले लीजिए फोटो खींच के
अरे
आप
सर, अरे यार
ठीक है
दुर्गा पूजा के पहले पेमेंट करेंगे ना. सरकार नाम है इनका, बंगाली होंगे, दुर्गा पूजा मनाते होंगे. ठीक है.
हम इंस्ट्रक्शन दे देंगे
Post this case on 7th October in the supplementary cause list. It is expected that in the meantime the amount will be disbursed to the petitioner. अगला डेट में क्लोज कर देंगे. क्वांटम पे डिस्कस करिएगा.
नहीं उस पे नहीं कर, उसके लिए तो नया रेट करना होगा.
ये ओपी नंबर 2 इसमें क्या फाइल किया?
कॉफी शाम को लेंगे हम कभी जो वही रहेंगे यूनिवर्सिटी आप
हमने दिया है उसमें इंस्ट्रक्शन सीख किया उस पेपर से
Affidavit on behalf of the university has also been made. इसके content.
अब वो रिलीवेंट हो गया
अब वो irrelevant हो गया लेकिन रिकॉर्ड पे तो जाएगा ना.
हाँ रिकॉर्ड पर ले हमने 24 सितंबर को उनको दिखा
मिस्टर सिंह इसको कराइए आप.
हाँ ये अभी फोन करेंगे बाहर जाके चिट्ठी दे इसको
कुछ
अभी
नहीं, चिट्ठी नहीं देना है. आप उसको क्लिक करिए और भेज दीजिए.
करने नहीं आता है
व्हाट्सएप कर दीजिए.
हम कर दे रहे हैं
चलिए.
वो कर दे हम आपको नहीं कर रहे हैं
आपको पेमेंट मिल जाए तो हमको क्या मतलब है?
हम समझते हैं कि हमने एडवांस सब्सिस्ट नहीं कर रहे हैं
देखिए
ठीक है
उत्सव का समय है. ये समय किसी के लिए लौट के नहीं आएगा. इसलिए लेट देम बी हैप्पी
नहीं
एंड सेलिब्रेट.
Waiting for admission, item 33, content will be 266 of 2023.
Yes, tell me.
Let's kindly see the last document notes.
आपको कितना गुजारते हैं?
इसमें भी नहीं हुआ है पेमेंट. कहते कि
हो गया ना पेमेंट. अब क्या बचा है इसमें?
नहीं हुआ.
इस पर भी एक सप्लीमेंट्री इस पर रख दिया ये क्या हो
मेरे
क्या हो गया इसमें?
होती नहीं है ना
हाँ कॉपी
हाँ क्या हो गया बताइए.
सारा पेमेंट
नहीं हुआ है. कब हुआ है? जैसे एक बार दे दिया आपको कल तक तो नहीं बताया गया कि पेमेंट हुआ है.
आपको मेरा होगा
24/9
24
सारा हम लगाए हुए स्टेटमेंट
ये तो फिक्सेशन है पेमेंट किया कि नहीं ये तो बताएंगे.
हम लोगों ने रिलीज कर दिया है पेमेंट करने के लिए इंस्ट्रक्शंस दे दिया है सारा स्टेटमेंट
आप किनको रिप्रेजेंट करते हैं?
यूनिवर्सिटी को
पेमेंट है
यूनिवर्सिटी ठीक है हमने अमाउंट रिलीज करके ऑथराइजेशन दे दिया है और द अमाउंट टू बी क्रेडिटेड उसको जो देख लिया जाए ना एक एक आइटम वाइज एक एक आइटम पर पढ़
till 10:30 she has called me no payment was to her. और ये अभी हमको कॉपी दे दी.
एक सेकंड बताइए कहाँ पर है आपको?
इसमें भी
देखिए
पे-
एक सेकंड. पैरा 5 सबसे पहले ग्रांटेड प्रमोशन पैरा 4 उसका पैरा 5 will be paid shortly.
एक तो पैरा 5 में का हो गया ग्रांटेड प्रमोशन इन रैंक ऑफ रीडर अंडर 10 years टाइम बाउंड प्रमोशन इज नोटिफिकेशन क्लोज then comes annexer B pay fixation of the petitioner in the rank of reader has been done annexer B series 6 above mentioned pay fixation the admissible dues of the petitioner will be paid short that the answering of the
पे करके आइए ना.
ठीक पे फिक्सेशन हो गया प्रमोशन हो गया
पे
ठीक है
पे करके आइए कि
बिल्कुल।
ओल्ड लेडी को हम दौड़ाएं.
नहीं कर कर देंगे, we will कर देंगे provision का.
Content case civil number 266 of 2023. A supplementary show cause has been filed on behalf of opposite party number 2. A statement has been made in paragraph 4 that promotion has been granted. Petitioner को कि इनके husband को?
इनके husband को.
तो we don't have the
ये उनकी
petition.
widow है.
To the husband,
One of
लेकिन
my-
इसमें petitioner लिखे हुए हैं ना? अच्छा
ना,
इससे.
हम
Promotion has been granted with effect from 18/8/2025 and the pay fixation has been done
Yes.
in the rank of reader by memo dated 24/9/2025 and in paragraph 6 it has been stated that the admissible amount will be duly paid to the petitioner shortly.
Yes. I will
Yes.
show.
The amount having not yet been paid, this court is not inclined to close the contempt proceedings. Post on 6th October.
नहीं, अभी तो बंद हो जाएगी बस थोड़ा टाइम दीजिए. हम करा थोड़ा टाइम दीजिए, करा जरूर देंगे. इतना कर
14th October.
हाँ, ठीक.
Post on 14th of October 2025 in the supplementary cause list. In the meantime, the admissible amount be released.
ठीक.
वो जो दोनों ऑर्डर्स हैं ना, आप काइंडली इनको प्रोवाइड करें. ये जरूरी है ना, जो पे फिक्सेशन हुआ है.
हम
हम
इनको
भी
ये
कर दें.
प्रोटोकॉल की कॉपी अभी तुरंत दिला दें. उसमें सब कुछ लिखा
वो
हुआ है.
रीडर का भी है ना, वो उसका
हाँ ये अभी डिफरेंस है बच्चों की ऑर्डर में है 12,000 का पे स्केल, इसमें कितने फिक्स किए 10,000 का स्केल. फिर एक चक्कर फिर लगवाएंगे. रीडर का पे स्केल 12,000 का.
कोई बात नहीं. उसके लिए आपको एक चक्कर और लगाना पड़ेगा.
और भी सुनो.
बोल रहे और किसको कितना दौरा है.
थोड़ा कमाएगा और फिर और कितना
सर ऐसा नहीं.
करा देंगे.
ओल्ड लेडी से कमाई का जरिया मत
नहीं,
बनाइए.
नहीं,
वो भी उनके पेंशन के पैसे से.
एक्चुअली
अच्छा नहीं लगा.
राजेश कुमार वेलफेयर का सोच रहे हैं. इनके हित में सोच रहे हैं. अब करा देंगे उसकी.
करा दीजिए उसको.
बिल्कुल करा देंगे. और नहीं.
Under heading for hearing under order 41 rule 11 of OPC, item 35, second appeal 373 of 2018.
Yes.
I was the defendant in the title suit. This matter is of confirmation. The decree was modified in the accurate court version. The plaintiff had prayed for declaration of right title interest and confirmation of possession or in the alternate recovery of possession version. Plaintiff had purchased 4 kathas of land in 2 plots, plot number 103 and plot number 106 in the year 1982. And he has alleged that the defendant had started disturbing his possession, and to fortify his disturbance, he had gone ahead and filed section 144 application for the SDM lordship in 2 occasions, your lordship, once in 2003 and once in 2007. Both the times, your lordship, it was decided in favor of the defendant, your lordship. Also, your lordship, the plaintiff has claimed that in 2000, your lordship, he had filed a measurement case before the circle officer in which the Amin had given a report regarding the possession, your lordship. Now, your lordship, in the defendant had filed a written statement in which he has claimed that the wife of the defendant had purchased half cut of land in 1982 of plot number 103 only, and his relative had purchased 2 dismil of land in the same year, who had subsequently again sold it to the wife of the defendant in the year 2004, your lordship. That is half cut of land and 2 dismil of land here, your lordship. We are claiming over these land, your lordship. The plaintiff, your lordship, we have also filed a rent receipt accordingly, the order of the mutation and the SDM report, your lordship. SDM order, your lordship. The titles in the title suit, it has been held that, your lordship, both the parties hold their title, your lordship. And the title of both the parties have been established, but the possession has been declared as per the Amin report, your lordship, and the defendant was or directed to hand over the possession of the plot. This measurement was again modified, amended in the appellate.
Based on the report.
Based on the report, that is the only basis of the
Report is an undisputed document.
Your Lordship, we have not challenged the measurement case, that is,
So therefore-
but we are saying that we were not available when the measurement had taken place. Your Lordship, this is one, but the main ground, Your Lordship, that there is a patent ambiguity in the odd decree, Your Lordship. The decree is not executable, Your Lordship. They have
That
said
you will take at the time of execution. That you will take at the
Your
time
Lordship,
of
but this is
execution.
not, I also
That
have
is
judgment,
open-
Your Lordship.
It is open to you to have an objection at the time of execution that it is not executed.
Your Lordship, you may see, Your Lordship, the Amin report also does not have any boundary, Your Lordship. The sale date based on which they are relying on, that also doesn't have any boundary, Your Lordship. If this goes in execution, Your Lordship, my plot is held to be there, Your Lordship. I have also been held to have title to that property, Your Lordship. If this is allowed, Your Lordship, my property also might go, Your Lordship, in handing over, Your Lordship, because there is no boundary. It has just been said that 615 square feet of land on the east portion of the plaintiff's house may be handed over. There are two plots, Your Lordship. The length, breadth of both the plots have not been given. Your Lordship, if I may pass the judgment, Your Lordship. Your Lordship, para number 9, Your Lordship.
This is arising out of execution proceedings.
Yes,
You
Your
can
Lordship.
object, please.
Your Lordship, here, but if the matter is before Your Lordship, then the order is
No,
not
we will not
executable,
decide
Your
it
Lordship.
is not executable. That will be decided by the execution.
Also, Your Lordship, in the plain, Your Lordship, it has nowhere been mentioned on which day I have become. I have been held to be the trespasser in that disputed land, Your Lordship. In the plain, it has nowhere been mentioned, Your Lordship, on which date I have entered into the encroachment, Your Lordship. It is vague, Your Lordship. Somewhere it said in 2001. It has been held that since 2008. The property has been purchased since 1982, Your Lordship, by both the parties. Your Lordship, kindly take into consideration the judgment, Your Lordship.
That is on arising out of execution proceedings.
Your Lordship, but this matter is already before Your Lordship, Your Lordship.
We are not here to decide whether the decree is executable. Which para are you referring to?
Para 9, Your Lordship.
Or the council of name and of the accident. This appeal has been filed against the judgment dated 23/7/2018 within bracket decree signed on 27/7/2018 passed by learned District Judge 1 Dhanbad in civil appeal number 32 of 2018, whereby the learned first appellate court has been pleased to partly allow the appeal, directing the defendant to hand over the vacant possession of enclosed portion measuring an area of 615 square feet of land towards east side of the house of the plaintiff, failing which the plaintiff would be entitled to recover its past possession through the process of law. The trial court judgment is dated 2/2/2018 within bracket decree signed on 12/2/2018 passed by the civil judge within bracket Jubilee Division bracket close 1 Dhanbad in bracket suit number 99 of 2008, whereby the suit was decreed. The learned counsel for the appellant, by assailing the The defendant is before this court. The learned counsel for the appellant, while stating the improved judgments, has submitted that the deed itself did not have the proper boundary,
Even the Amin report
and the Amin report also did not have the proper boundary, which is the basis to calculate the area of encroachment, and no specific boundary in connection with the area to be recovered, that is 615 square feet, has been mentioned in the judgment passed by the learned first appellant. The learned counsel has submitted that in view of this discrepancy, the decree is not an executable decree. That's it. She submits that a substantial question of law be framed and decided. She has referred to the judgment passed by Honorable Odisha High Court reported in 1981 SCC online Odisha 62, which was arising out of an execution proceedings. Though it was arising out of an execution proceedings, but she has referred to paragraph 9 thereof to submit that when the description of property is vague, suit cannot be decreed. That's it. After hearing the learned counsel for the appellant, this court finds that the suit was filed for a decree for declaration of title in respect of the land of Schedule A as purchased by registered CLD number 4841 dated 19/1982, and also seeking confirmation of possession with a further relief that if the plaintiff is dispossessed during the suit, then for recovery of past possession of the suit property.
also the date of encroachment is also
The
not
learned
mentioned.
counsel has also submitted that there is no specific date of encroachment by the
Plaintiff. By the defendant.
by the defendant in the records. The case of the plaintiff is that the plaintiff had purchased 4 kathas of land pertaining to plot number 103 and 106 under khata number 105, wide CAD number 4841, dated 19/1982, from the rightful owner named Visual Bush. And came in possession. But the defendant started creating disturbance and interfering with the possession of the Schedule A land by tying his cows and buffaloes. A proceeding under section 144 CRPC was initiated by MP case number 372 of 2003. And as per the plaintiff, the decision of the court was incorrect. It was further case of the plaintiff that after purchasing the suit land, he had constructed a boundary wall in the year 1982. And as the northern wall of the plaintiff land got damaged, the plaintiff wanted to repair the damaged wall for the purposes of safety and privacy. But the defendant, without any justification, started creating trouble. And in order to cause demarcation, the plaintiff filed an application before the circle officer Nambad for measurement of the land. It was measured in measurement case number 23 of 2001-2. The circle officer submitted a report, and it was asserted that the defendant had no right title interest in possession with respect to the suit land. the plaintiff had also had the rent receipts granted by the state, and since the defendant was bent upon dispossessing the plaintiff from the suit land, the suit was filed. The defendant suit was filed. The schedule to the property, the schedule of the suit property as contained in Schedule A is mentioned as follows. The appellate court judgment में ही है Schedule A का. The defendant filed a written statement and they asserted that the plot was recorded under Abad Malik under Khata number 105 under Khewat number 15, and there were several Khewatdars. One of the Khewatdar was Amulya Ratan Ghosh and his grandson was Yutish Ghosh, and another was Rajnikant Chaube. His son was Shivkant Chaube, and Yutishar Ghosh was in possession, sold half kattha or say 8 chatta to the wife of the defendant in plot number 103 with specific boundary in the month of February 1982. And another Khewatdar, Shivkant Chaube, in possession, had sold a portion of plot to Rameshwar Yadav and put him in possession, and he was close relative of the defendant and was in possession since March 1982. And since then, the wife of the defendant and Rameshwar Yadav were in peaceful possession and got their name mutated and also constructed boundary over the purchased land. It was asserted that the deed of the plaintiff was fraudulent and collusive. And there has been 2 MP cases before the revenue authorities, before the sub-divisional judicial magistrate. One was MP case number 372 of 2003 and other was MP case number 1234 of 2007, which were decided in favor of the defendant. It was asserted that it was false for the plaintiff to say that he had constructed a boundary wall and the question of repairing by him does not arise. It was asserted that the Amin's report was a terrible report. The defendant stated that the plaintiff has not acquired any title by virtue of the alleged deed, by virtue of the deed, and the legal heirs of the recorded Khewatdar was in peaceful possession, who were in peaceful possession have transferred 2.5 kattha to the wife of the defendant and Rameshwar Yadav, who had later on sold to Chandiya Devi by registered Sethi number 8049 dated 6/10/2004. Chandiya Devi is not a party in the proceedings. The entire property was sold.
The entire property was sold to Chandiya.
Admittedly, Chandiya Devi is not a party to the proceedings. The learned court framed as many as 12 issues for consideration. Both the parties adduced documentary and oral evidence in support of their case. The learned court took up issue numbers 7 and 10 as the main issue, and after considering the materials on record, came to a finding that the plaintiff has been able to establish his title over the suit land on the strength of the CD number 4841 dated 1982, and both the issues were decided in favor of the appellant, in favor of the plaintiff. ये वाला ना पैरा 8 पैरा 8 पूरा ही बोल रही हूँ. So far as issue number 9 and 11 are concerned, the same were also decided in favor of the plaintiff by paragraph 9. The Amin's report was considered by considering issue number 8. The exhibit 4, which was Amin's report, has been perused, and it has been perused by the learned trial court, and it has been recorded that it was evident that circle officer had ordered Anchal Amin to measure the land of the plaintiff and to submit a report. And exhibit 4 by A revealed that Anchal Amin had shown the site map countersigned by the circle officer Dhanbad, and out of the purchased land of the plaintiff, measuring an area of 83 by 4 into 32 1 by 3 feet. Some Sahdev Yadav had occupied an area of 34 into 5 feet in eastern portion, and west to the same an area of 17 3 by 4 into 34 3 by 4 has been occupied by the defendant, and land area of 58 into 32 1 by 3 feet only has been found in the occupation of the plaintiff. In the map, a total area of 174 square feet was shown as enclosed by Sahdev Yadav as his house over the same, and area 615 square feet has been shown as enclosed by Javeshwar Yadav defendant as vacant land. The defendant claimed to have constructed cowshed over the same, but the site map showed that it was barren land. In cross-examination, the plaintiff had stated that the defendant forcibly occupied his land 8 years ago and he was not allowed boundary over the land. The learned trial court, after considering the materials, has also recorded that the defendant did not make any claim of title by prescription and was of the view that the enclosed land of the plaintiff was recoverable and decided the issue number 8 accordingly. The other issues were also decided in favor of the plaintiff and the suit was ultimately defeated. So far as the learned first appellate court is concerned, the points for determination before the appeal have been recorded in paragraph 11 of the appellate court's judgment. The learned court recorded that the suit property was identifiable by paragraph 17 and by paragraph 18 it has been recorded that the defendant who was examined as DW1 has stated that there is 7.2 decimal of land in plot number 103 and about 45 decimal of land in plot number 106, and he has stated that his wife had purchased the land also in plot number 103 and 106. He has stated that the suit land is situated in Khata number 105, plot number 103 and 106. And on the north side of plot number 103, 8 chatak of land was sold by Jyotishwar Ghosh to his wife, dated 28/2/1982, and they were in possession. He also stated that on the north side of plot number 106, another Khevardar had sold the land to Rameshwar Yadav on 1/1982 by registered deed, and he was in peaceful possession. And they had constructed the boundary. And Rameshwar Yadav has sold his land to his wife by registered deed number 8049 dated 6/9/2014. 2004. 2004? Yes, 2004. 2004. So he has stated that his wife also purchased land of 8 chatak in north side of plot number 103 from the Jyotishwar Ghosh, who was also the vendor of the plaintiff. And also one Khevardar had sold the land on 1/3/1982 to Rameshwar Yadav on the north side of plot number 106. And later Rameshwar Yadav sold the land to his wife. The learned court ultimately recorded in paragraph number 24 that defendant cannot deny that Jyotishwar Ghosh had the right to sell the property, and held that the sale deed of the plaintiff was legal and enforceable, by which he had purchased 4 kathas of land, and boundary has been mentioned, in which the same boundary has mentioned in Schedule A of the property of the plaintiff. In paragraph 28, further finding has been recorded as follows. And found that the learned court has wrongly calculated the area of encroachment. Such finding has been recorded in paragraph 29 and 30. 29, and it has been ultimately held that the plaintiff is entitled for recovery of only 615 square feet of land. This court finds that the first appellate court has considered the measurement to come to a finding, the finding on the area of encroachment. The court has recorded that the suit property was identifiable, and ultimately the appeal was partly allowed by holding that the plaintiff would be entitled for possession only to the extent of 615 square feet of land, which he has encroached as per Exhibit 4.8. The argument of the appellant that the area of encroachment was not identifiable is not correct in view of the findings recorded by the learned court. And accordingly, the judgment cited by the appellant does not apply to the facts and circumstances of this case. The findings by the learned first appellate court and the modification made by the learned first appellate court with respect to area of encroachment has been done by a very recent judgment. This court is of the view that no substantial question of law arises for consideration. There is no scope for the appreciation of the judges on the law at this stage of suit.
The voting may be given to raise the objection to the execution petition regarding the ambiguity of the motion.
That right is always there.
We just to mention it.
That right is always there. You can't say anything.
Item 36, second appeal to 54 of 2020.
I prayed for adjournment yesterday.
Second appeal to
Only after vacation, any day.
When it comes for the appellant, seeks adjournment, and he submits that in advance notice seeking adjournment, I can supplement it. इतना मेहनत करके आपका नोटिस सर्व कराते हैं, जब केस टेकअप होता है तो आपको adjournment चाहिए। नोटिस सर्व कराने में हम लोग का हालत खराब है। Because you know people have become restless, they have lost hope, isn't it? Fact है ना? फोन नहीं करते ना लोग, छोड़ के चले गए। They have left, या कुछ होने वाला नहीं। बहुत मुश्किल हो रहा है नोटिस सर्व कराने में। We are asking the police authority to serve, क्या हम नहीं कर रहे हैं नोटिस सर्व। आपको एजेंडमेंट चाहिए 5th of January 26.
Only after 2 weeks. Otherwise, only praying.
आज एजेंडमेंट आप मांग रहे हैं,
हाँ
डेट
नहीं
हम अपने
नहीं,
चॉइस
तो it is for your lordship.
5th January ओपनिंग डे है, याद रखिएगा।
Item
हम
37.
तो whatever is coming.
5th January.
Item 37, second appeal 83 of 2021.
Yes.
Today the adjournment मांगे, मेरा पर्सनल रीजन, पहली बार कभी नहीं मांगे, कोई भी डेट दे।
आपने एजेंडमेंट नोटिस दिया है?
नहीं, हम बोलना नहीं चाहते। कल कुछ चश्मा मेरा टूटा है, आज हम रीडिंग चश्मा लेके आ गए हैं, लेकिन थोड़ा सा डिफिकल्टी है, ये हम बोलना नहीं चाहते। कोई भी डेट आप कर दीजिए, ओपनिंग डे में कोई भी डेट। इसमें कॉज ऑफ एक्शन से कॉज ऑफ एक्शन नहीं है, इसके कारण दोनों सूट नहीं है।
जबकि वो वहीं पे जमीन पे ही है और वो बोलते हैं कि उसका जमीन से कोई लेना देना नहीं।
Where the plaintiff
जी आप
cast in both the courts.
प्लेंट
SU number 83 of 2021. The learned counsel for the applicant seeks adjournment on account of his personal difficulty. No advance notice seeking adjournment has been circulated. The case has been adjourned time and again. And on the last occasion, the adjournment was granted upon payment of cost of rupees 1,000. Since he has mentioned about his personal difficulty, post on 5th of January 26. बहुत सही टाइम है।
पहले नेक्स्ट
Item 38, second appeal 36 of 2022.
क्या बोल रहे हैं?
ठीक
27 करते हैं?
नहीं 20 कल
27 जनवरी 27 करते हैं?
नहीं अभी जो डेट थी
ठीक है? चलिए। अब बोलिए।
38 and 39 yesterday I had given.
आप लोग ये एडजर्नमेंट का जो कर रहे हैं ना 2-2 साल एडजर्न कर देंगे आपका केस 2-4 लोग मर जाएंगे अपने सब्स्टिट्यूशन करते रहिएगा क्या कर रहे हैं आप लोग व्हाट इज इट सेकेंड अपील पड़ा हुआ है 2022 से 3 साल हो गया है 30 साल बीत जाएगा क्या दिक्कत है ये मत बोला करिए ना केस नहीं टेक अप होता प्लीज डोंट यू आर नो बिजनेस टू से दिस हाई कोर्ट में केस पेंडिंग है सुनवाई नहीं होती किसी वकील को बोलने का ये जुरिस्डिक्शन इस कोर्ट में तो बिल्कुल भी नहीं यहाँ पे खाली एडजर्नमेंट का काम चलता ओनली एडजर्नमेंट करेक्ट और आपके सीनियर नहीं खड़े होंगे एडजर्नमेंट लेने में उनको पता है अभी कॉस्ट लगा देंगे आपको खड़ा कर दिया
छुट्टी को
शर्म नहीं आ रहा जूनियर को खड़ा कर दिया है एडजर्नमेंट लेने के लिए वहां बैठे हुए कोना में
नहीं हम तो खड़े नहीं छुट्टी की बात
ऐसे नंबर 36 of 2022 defendant is the appellant before this court after having lost in 2 cases advance notice seeking adjournment has been circulated notice complete hai
Your Ladyship, we have appeared on by filing cabinet.
okay or for all the respondents
We have yes, Your Ladyship.
do you have any urgency in the matter
Since we are not in possession, they are in possession, and previously
they
also
have lost
they have lost, but till now they have not filed execution. I have advised on the last date. I have advised them to file.
they have lost your client has not filed any
Not
case.
filed. Last occasion they came. I advised them that you file execution immediately.
अच्छा एग्जीक्यूशन जब हो जाएगा तब आएंगे इनको फर्स्ट वीक नेक्स्ट फरवरी का डेट दे दीजिए मंडे
Lordship, on our behalf, we will be praying for a shorter dates because
why shorter date you have not yet filed your execution you are not bothered about it
that is other thing. They were not advised, and then when they came to me, then I have advised them. I was only praying that since the matter is pending and it is present before the honorable court. So
आपसे तो कंसेंट लेके न दिए हैं
I have told him. He called me. I told him it is not by consent.
नहीं information
He just called me yesterday when I was returning home. I said that I cannot give consent. He said that I will just inform. So it is not that we have consent.
चलिए ठीक है इतना लंबा मत डेट मत दीजिए आप बहस करेंगे ना यस आप बहस करेंगे तो शॉर्ट देते हैं पक्का एक अक्टूबर बोथ द केसेस दोनों केस हैं
ये तो 9
अच्छा एक ये वाला 8 को कर दीजिए नेक्स्ट वाला 9 ठीक है
और नेक्स्ट Item 40, second appeal 61 of 2022.
कोर्ट सही नहीं चल रहा है क्या
नहीं लॉर्डशिप सीनियर का तबीयत सही नहीं है
नहीं हमको लग रहा है कोर्ट सही नहीं चल रहा टाइम मांग रहे हैं
सीनियर एंगेजमेंट केस है ही इज नॉट वेल लॉर्डशिप
Have I caused any discomfort?
नो लॉर्डशिप
हाँ?
नहीं ऐसा बात नहीं है क्योंकि
और
पूजा भी
vacation-
चल रहा है हम लोग सब पूजा में बैठते हैं पढ़ नहीं पा रहे पूजा भी चल रहा है इसीलिए मेन कारण है एडजर्नमेंट का पूजा का चलते हैं अदरवाइज हम लोग टाइम लेते भी नहीं
भगवान को दोष दें
नहीं भगवान हम अपने को दोष दे रहे हैं कि हम नहीं पढ़ पा रहे हैं हम अपने को दोष दे रहे हैं हम लोग पढ़ नहीं पा रहे हैं भगवान का ही नहीं करेंगे
भगवान की कृपा से इतना फाइल है
भगवान
आपके
की कृपा
पास
से है जो का आशीर्वाद से भी है
हमारा क्या आशीर्वाद भगवान जी का कृपा से आपके पास
बिल्कुल
इतना फाइल है
बिल्कुल तो पूजा चल रहा है शॉपिंग चल रहा है इसीलिए काम नहीं घर में भी देखना पड़ता है ना
तो यही का कमाई से न चल रहा
यही
है
तो मैं चल रही इसी को मुझे से प्रेयर करना है कि कम से कम पूजा के समय थोड़ा सा राहत दिया जाए
कब चाहिए
लॉर्डशिप इमीडिएट आफ्टर वेकेशन लॉर्डशिप
काउंसिल फॉर द फिनेंस एडजर्नमेंट एडवांस नोटिस हैज बीन सर्कुलेटेड और तो किसी को करना नहीं हमको लगता है सब एडजर्न करके हम क्या ही करें छुट्टी हो ही गया 4 बजे में कुछ ऑर्डर्स देखते हैं कर लें किस दिन
9 को
एक केस और आपका रखे हैं ना
Yes,
Voting में? आप बताइए कौन से दिन
8 को रखे लॉर्डशिप को 10th को रख
10 will be a Friday 14
14 को भी एक मैटर
तो अच्छी बात है 30 ऑर्डर
Under heading for orders, item 16, second appeal 376 of 2017.
there is an IA for substitution
of
of appellant number 1
who's for the respondent
notices have not been served notices have not been served yet
ये admitted
admitted
okay essay number 376 of 2017 counsel for the applicant is present IA number 13327 of 25 has been filed seeking substitution of the applicant number 1 who is said to have expired on 29/6/25 Wakalatnama of the proposed legal years and successors has been filed along with the eligibility application. The learned counsel submits that the second appeal has not yet been admitted and therefore notice has not been issued, but on the eligibility application it was been issued. Considering the opposing submissions, the notice be issued upon the respondents on ID number 12227 of 25 for which visits under speed post be filed by 7th of October. 7th October
8th कर दिया है
by 8th of October. Office to track speed post delivery. Post this case on 12th November.
Item 17, second appeal 73 of 2022.
Yes.
तीन आइए
Sorry?
आइए नंबर 1131 ये deletion of name of respondent number 6 में
इसमें नोटिस हुआ है अभी तक?
नहीं नोटिस नहीं
सब्सटैंशियल क्वेश्चन ऑफ लॉ बना है कि नहीं बना? इफेक्टिव में चल रहा है। देखिए आईडी नंबर 2113 of 2025. This petition has been filed for substitution of
respondent number 6 में
पहले किसी का डेथ हुआ है
हाँ उसके सब्स्टिट्यूशन फाइल किया है उसके लिमिटेशन है
तो उसमें नोटिस हुआ है
नहीं
तो उसको कौन बताएगा?
बोले अभी तीन आइए है इसमें
तीन आएंगे। बताइए कौन सा आईडी नंबर और किसका किसका सब्स्टिट्यूशन? आईडी नंबर 1 बताइए। अप्लीकेशन नंबर 11 के बारे में 11 के बारे में अप्लीकेशन नंबर 11
इसमें एप्लाइड नंबर 2 एंड 11 डेथ की है
2, 11 and 6 and defendant number 6. ये सबका जो मिक्स करके फाइल कर देते हैं तो कैसे किसको कैसे नोटिस
इसमें तो 242 डेज का डिले है
बिना नोटिस के तो नहीं होगा ना? नोटिस इशू हो गया इसमें?
नहीं नोटिस इशू नहीं
किसका वकालतनामा आप फाइल किए?
सभी का फाइल करते हैं
डिफेंडेंट का भी फाइल करते
नहीं डिपेंडेंट तो नहीं इसमें जो एप्लाइड नंबर 2 एंड 11 एंड 6 का 2 एंड 11 का
टू का लीगल ईयर कहाँ है? उसका नाम कहाँ लिखा है? कौन सा पैराग्राफ? What are the legal years of applicant number 2?
पैराग्राफ 4 में है
पैराग्राफ 4 में तो applicant number 11 का है।
दूसरा ये उसमें है
तो इसमें applicant number 2 का भी कहानी क्यों लिखी है?
चलती मक्का
This is for applicant number 11 और दूसरा कौन सा है? Next for respondent number 6 पहले इसमें लिखिए आईए नंबर 1131 of 25 in essay number 73 of 22. The learned counsel for the applicant has submitted that respondent number 6 has expired. The names of legal heirs and successors has been mentioned in paragraph 4 of the interlocutory application. He has submitted that the legal years and successors of respondent number 6 are already on record as respondent number 1 to 5. Let notice be issued to the respondent number 1 to 5 on the aforesaid interrogatory application for which requisites under speakers be filed by 13th of October. IA number 1134 of 2025 has been filed for substitution of ऊपर हेडिंग में नहीं लिखते हैं किसका सब्स्टिट्यूशन फाइल करते हैं और खुद को तो कुछ पता ही नहीं रहता. Appeal number 2. The name of the legal years and successors has been mentioned in paragraph 4 of the interrogatory application. This admits that the wakalatnama on behalf of the proposed legal years and successors have also been filed along with this interrogatory application. Let notice be issued to the respondents in ID number 2134 of 2025, except respondent number 6, who is said to have expired, as mentioned in ID number 2131 of 2025. For which requisites be filed by 13th October. और तीसरा आईए कौन सा है? आईए नंबर 2133 has been filed for
appellant number 11.
Substitution of appellant number 11, whose legal years and successors are mentioned in paragraph 4 of the interrogatory application. Wakalatnama on behalf of the proposed legal years and successors has already been filed along with the interrogatory application. Let notice be issued to the respondent to the proposed legal years and successors, and also to the let notice be issued to the respondents on the interrogatory application, except respondent number 6, who is said to have expired. The requisites be filed by 13 under speed post. सब में speed post से notice करेंगे, ठीक है? By 13. Office to track speed post delivery post on 4th of November.
Item 18, second appeal 119 of 2022.
In this case, limitation,
Sani, you just tell me, in these second appeals where people have died, ultimately क्या होता है? मतलब, I'm absolutely curious.
notice
Do the litigant ever come to you?
ये
हाँ, ये लोग सब आते हैं
आते हैं
पूछने के लिए कि क्या हो रहा है केस में.
हाँ आते हैं सेकंड एप्रिल बहुत केस जो 2004 का है तो उसका फोन नंबर भी निकला अब हम लोग चिट्ठी लिख लिख के परेशान थे कभी कभार जब डिसमिस पर डिफॉल्ट हो जाएगा तब फिर लौटता है ऐसा भी केस देखा
This
Now you-
ignorance and illiteracy is a prime concern.
yes in this case what happened in the matter of limitation notices were issued now the your lordship has been pleased to record below that earlier notices upon 1 to 5 were valid then 8/9/2025 this service report on respondent number 6 and 7 valid respondent number 8 died so I filed a substitution she left behind on husband that is paragraph 4
IA number
11654 sorry
13233
13233
in Essay number 119 of 2022. Counsel for the applicant has submitted that.
Paragraph 4.
Respondent number 8 has expired. The name of legal heirs and successors has been mentioned in paragraph 4 of the interlocutory application. Let notice be issued to the proposed legal heir and successor, for which requisites under speed post.
She happens to be the sister of this appellant. So I have instruction, of course I don't have no Okalatnama, he is collecting, and he can appear through lawyer.
एक बार आप थोड़ा सा speed post
नोटिस
का
से कार्रवाई
notice
कर दें।
requisites by 7th of October.
Yes.
7th of October. Through speed post. Office to track speed post delivery. Post on 30th October.
Or prior to that, so that he will file the Okalatnama immediately after that. I will take these steps, and thereafter immediately thereafter Okalatnama will come. So any day prior to.
Prior to 30th.
Yes.
22nd.
Yes.
नहीं 22nd तो छुट्टी दिखे हो।
22nd declare.
आप ऐसा करिए अगर आप परसों फाइल कर देते हैं तो हम ओपनिंग में रखें। Requisite
अभी
कर
फाइल
देते
करो,
हैं।
कल परसों तो नहीं है, कल दे देंगे।
हाँ कल
दे देंगे।
by tomorrow.
Yes.
Right. And post on 6th October. 7th October.
Item 19, first appeal 272 of 2023.
Lordship, we tried to serve notice on respondent number 10. However, it was not served through both the processes. Currently, the service report says that respondent number 10 does not reside at the address that was mentioned. So we are seeking 4 weeks to locate him so that we could serve him.
Appeal number 272 of 2023. Counsel for the applicant prays for and is granted
4 weeks.
time till 10th of November to take fresh steps upon for service of notice upon respondent number 10 at his present and private address. The requisites be filed under speed post. Holds this case on 9th December. Office to track speed post.
Item 20, first appeal 62 of 2024.
Notices were issued, so all those have been validly served. Respondent 1 and 2 have appealed through It's part of the batch wherein the tribunal had relied upon a judgment which was rendered or modified with the Torchlight service. Other than
So one judgment I have uploaded.
it's not FA 48 of 20.
It was dictated in the court. Defect has been ignored.
Yes. It's the limitation is
Limitation to be controlled.
it has to be
382 days. But they have not entered appearance.
respondent 1 and 2 have appealed to the
And rest services.
valid service.
There are two IAs. There is a separate IA for combination of delay.
Yes, there is one IA for combination of delay, the other one was for the taking ignoring of defect for the point that certified.
That has already been
That has
done.
already been.
This 4196 is only for combination of delay. Where is the delay in filing the first appeal?
Yes.
Okay, appeal number 62 of 2024. The learned counsel for the applicant has submitted that the notice has been served upon the respondents either personally or through their close family member. Submits that notice may be accepted as valid and the petition for and delay be controlled in filing the present appeal. Respondent number 1 and 2 have already appeared by filing for Canada. However, nobody is appearing on behalf of the respondent. On behalf of the respondents. The learned counsel has referred to paragraph which paragraph are you referring to? Paragraph 5 to 11, right? 5 to 11 of the interlocutory application, and decides that the matter relates to land acquisition proceedings, and similar matter has already been decided by this court. On the point of quantum of compensation. Considering the evidence made in the petition seeking condemnation of delay and being satisfied with the caution IL number 4196 of 2025 is hereby allowed and delay is hereby terminated. This has to be formally admitted. Now the point is that we have issued them notice only on the point of limitation. In the appeal, the notice has not been issued. Correct?
By order dated 8/4/25.
Yes.
On the point of
Only on the point of limitation. So fresh notice has to go. Had they been appearing, there was no problem. That is the procedure.
but respondent number 1 and 2 appears.
Admit. Respondent number 1 and 2 has already entered appearance. Therefore, no fresh notice being issued to them. So far as the respondent number 3 to 5 are concerned. 6 also.
6 is deputy commissioner.
कहाँ है डेप्यूटी कमिश्नर? पिछली बार थे मैं.
Advocate Sanjay Kumar Tiwari.
चारों में कर दीजिए. Let notice be issued to respond number 3 to 6. Through speed post.
May I point out the order dated 8/4/25.
Yes.
But we should notice to the respondent that the loyalty process in IM seeking condemnation of delay
Oh, and also in the first appeal. That's right. That's it. Yeah, ma'am. Service is complete. Admit post this case for final disposal on date of it.
the other matters are listed on 4/11, but in those cases, notices have substitution has to be done. One batch was listed yesterday, so it would come up on Wednesday.
On Wednesday next it will come. So 8th को रख देते हैं. On 8th. Records इसका कहाँ से लेंगे?
It's part of FA number 48 of 2024.
FA number 48 of
2024.
the learned counsel submits that the records are already available in FA number 48 of 2020. Let the records of FA number 48 of 24 be placed along with this.
Sure, I must also point out that in the other batch cases wherein limitation was condemned, there was cost of 5,000 euros.
Not done.
Those cases we have done. The details, 8 cases were disposed of. In 6 cases we were provided the account details. We have waived the payment
तो है ही नहीं कोई तो उसको
We
पर्सन
have served a
we
motion.
can't do anything. Okay. They are not interested in this. In that case, they were opposing the condemnation. That's why.
Item 21, first appeal one.
Yes.
Yeah.